एक्स्ट्रा लग रही है अनवर भाई एक सैनिटाइजर का म्यूट है। ऑन कर दो।
आज की शाम की आप सबको नमस्ते, गुड इवनिंग। समाधान का ये पैनल डिस्कशन का प्रोग्राम अलॉन्ग विद रिलीज ऑफ कैलेंडर ऑर्गेनाइज जो किया गया और आप सब पधारे हो, आपको नव वर्ष की बहुत बहुत शुभकामनाएं। जस्टिस संजय किशन कौल, जज सुप्रीम कोर्ट ऑफ इंडिया, मिस्टर आर वेंकटरमणी, अटॉर्नी जनरल फॉर इंडिया, जस्टिस A.K. Sikri, former judge, Supreme Court of India, Justice Satish Chandra Sharma, Honorable the Chief Justice, Delhi High Court, all the honorable judges of our High Court, all the honorable judges from various district courts, Mr. Chetan Sharma, Additional Solicitor General, judges in charge and coordinators of various mediation centers in Delhi, Mr. Mohit Mathur, Mr. Jatan Singh, Mr. Sandeep Sharma, President, Vice President, Secretary and all other members of the Bar Association, executive members of all other bar associations, senior advocates, mediators, friends, ladies and gentlemen. I welcome you all on behalf of Samadhan. May I request Justice Sachdeva, Judge, Member Overseeing Committee of Samadhan, to welcome Honorable Justice Sanjay Kishan Kaul on behalf of Samadhan and present appointed plan to the Honorable Chief Justice, to the Honorable Justice Kaul. Potted plant. Thank you, Justice Sachdeva. May I now request Justice Verma, Judge, Member Overseeing Committee of Samadhan, to welcome Attorney General for India on behalf of Samadhan and present appointed plan to the Honorable, to the learned Attorney General. Thank you, Justice Verma. May I request now Justice Chawla, Judge, Member Overseeing Committee of Samadhan, to welcome Honorable Chief Justice on behalf of Samadhan. May I request Justice Sudhir Jain, Judge, Member Overseeing Committee of Samadhan, to welcome Honorable Justice Sikri on behalf of Samadhan. Thank you, Justice Jain. Samadhan has come a long way since 2006, from 2 small rooms to a state-of-the-art infrastructure comprising presently more than 30 rooms spread over 3 floors with well-equipped receptions and large waiting areas for litigants and lawyers. It also has a psychologist's room, a bright and cheerful children's room, and pantries, one on each floor, with regular supply of tea and coffee. Samadhan has succeeded as a lawyer-run mediation center because of the proactive support of our judges. This collaboration between the bench and the bar has built bridges of trust and faith amongst all stakeholders of mediation. Together, we have empowered disputants to resolve their conflicts and find peace and harmony in their lives. Samadhan has woven a change in the perception of conflict, the treatment of disputes, and the dispensation of justice, both in court-referred and pre-litigation matters. Samadhan gets its own calendar made over since 2011. A calendar is much more than it obviously portrays. For the Samadhan family, it is a reflection of our commitment to empower parties to find closer to their conflicts, a reflection of the philosophy of mediation, and a reflection of our belief in the power of the human spirit. Our calendar finds center space on every table in the mediation rooms and works as a silent but effective participant in the mediation process. Each year's calendar is carefully thought of, and every effort is made to pick up a relevant theme that illustrates an important aspect of mediation. Different quotes with matching photographs are then strung together to capture the chosen theme for all the 12 months. We missed our brainstorming sessions on the calendar during the last 2 years of COVID. However, we have made every effort to see that this year we have a special theme on two powerful ingredients. In our experience, have been several disputes made the vital difference between the settlements and non-settlements. Sadhana, JP, Sudhanshu, and Kiran Kalra, our calendar coordinator, have made it possible to see calendar of the year 2023. All kudos to our designer, Mr. Vinay Jain, who has always come out with excellent pictures to express the messages accompanied by the quotes selected in line with the theme of the calendar. The theme of the calendar is apology and forgiveness. In mediation, I'm sorry and other similar expressions of regret are not ordinary words. They pave the way for more fruitful dialogue and create a positive environment for collaboration without making specific admissions of liability. Similarly, true forgiveness is an equally therapeutic aspect of collaborative reconciliation. Therefore, as mediators, we believe only mediation can provide the parties a safe environment to acknowledge and forgive mistakes. Together, apology and forgiveness often become the heart and soul of the transformative journey of mediation. Samadhan believes that if mediators are equipped to help disputants in using apology and forgiveness, and if lawyers support this approach, it will lead to a transformative process of human healing and consequently a more harmonious society. This calendar illustrates the importance of apology and forgiveness in building relationship. जब हम किसी व्यक्ति को बहुत खुश देखते हैं ना, तो दो लाइनें उनके लिए मैं कहना चाहूँगी, उनका एक्चुअली क्या उनका व्यवहार रहता है। कुछ इस तरह मैंने जिंदगी को आसान बना दिया, कुछ इस तरह मैंने जिंदगी को आसान बना दिया, किसी से माफ़ी मांग ली और किसी को माफ़ कर दिया. So that is the essence of apology and forgiveness. May I request my Lord, Honorable the Chief Justice, to kindly grace the dais and do us the honor of releasing Samadhan calendar of 2023. Neelam, may I request you to escort the Honorable Chief Justice. my lord. May I request Mr. Mohit Mathur, just sir, my lord, just for 1 minute. May I request Mr. Mohit Mathur to present memento to Honorable the Chief Justice on behalf of Samadhan. Thank you, Your Lordship. This moment shall always be cherished by members of Samadhan family. We are a country of more than 1 billion people, having innumerable conflicts and disputes. In spite of having a well-equipped legal system, we are not in a position to match with the inflow of cases. In this scenario, mediation becomes a very crucial mechanism in dispensation of justice and social engineering. In today's time, when the Singapore Convention has been signed by India and the mediation bill is in the offing, Samadhan, under the leadership of our chairman, Justice Manmohan, and all other honorable judges, members of our overseeing committee, decided to have this panel discussion on the topic Evolving Justice Through Mediation. May I request Justice Kaul to grace the dais, and may I request Anuj to escort Justice Kaul to the dais. Justice Kaul has held Samadhan's hand and nurtured us from the time he was the youngest judge member of the overseeing committee till the time he left us as chairman of the overseeing committee. He has always worn his counsel's gown when it came to mediation, and especially when it comes to Samadhan. He has given us the extended state-of-the-art infrastructure that we have today, luckily for us, when he was the chairman of the overseeing committee. We are more happy because of this. This happened because he was the chairman of the building and maintenance committee also at that point of time. Thank you, Justice Kaul, for being with us as always. May I request the learned Attorney General to grace the dais. May I request Mr. Tarveen Singh Nanda to escort Mr. Venkatramani to the dais. We are also happy to have Vijaya with us, who is a part of legal fraternity. Thank you, ma'am, for being with us today. Mr. R. Venkatramani, the Attorney General for India, whom we also know as a brilliant constitutional lawyer, scholar, jurist, activist, author, mentor to many, is a humanist first. He is the first lawyer to be appointed as India's Attorney General directly to the constitutional position without having been any law officer before this. What makes him an obvious member of Samadhan family is his keen interest to know success stories of Samadhan wherever, whenever he meets us. Mediation reflects also in his advocacy skills that have always been gently persuasive, never combative. Thanks, sir, for accepting our invitation for today's panel discussion. May I request now Justice Sikri to grace the dais. I request Mitali Gupta to escort Justice Sikri to the dais. Justice Sikri has blessed Samadhan when we were learning to walk the talk of mediation. His vision, his compassion, his sensitivity, and belief in the idea of mediation made it possible for us to challenge ourselves by taking on all genres of subject matters in mediation. He motivated us when we were down and continued to foster us with every small success we had. It is his personal vision that still guides us in our daily struggles with difficult situations and difficult people. Thank you, Justice Sikri, for being with us today. May I request Justice Manmohan to grace the dais, and may I request Ajay Verma to escort Justice Manmohan to the dais. From Justice Sikri and Justice Kaul, Samadhan is now in the able hands of our chairman, Justice Manmohan, who has given us complete autonomy to sustain ourselves in the most challenging situations. His inclusive approach to involve the bench and the bar in a common pursuit for the cause of mediation has indeed made Samadhan proud to be a lawyer-run mediation center, proactively supported by our overseeing committee and all the judges of Delhi High Court. Thank you, sir, for being our guiding spirit and also being a part of today's panel discussion. May I now request the moderators of the panel discussion, Ms. Sadhana Ramachandran and Mr. Sudhanshu Batra, to be on the dais. Sadhana and Sudhanshu both are former organizing secretaries, internationally trained senior mediators, senior trainers, and they are going to facilitate today's panel discussion. Over to you, Sudhanshu and Sadhana.
Good evening, everyone, and all our dignitaries on the dais, off the dais, dear friends, and dear members of the family. This is a dream panel. We couldn't have had it better. Two former chairmen of Samadhan and one present chairman of Samadhan, whose indispensable contribution to the cause of mediation still guides us, and our humanist, compassionate, and very courageous Attorney General, from whom we have a lot of hopes, everyone in this hall, sir. So there's just one point I'd like to make before we start. Technically, we are calling it a panel discussion because the time that Justice Mohan gave us, the strict time that he gave us, allows only for that format. But emotionally, for the Samadhan family, this is our town hall, where the questions for our panelists today are from all the mediators. They've only been compiled by Sudhanshu and by me. So, with the permission of our honorable panelists, may we begin with Justice Kaul. In your lordship's view, sir, with your wide experience and sensitivity, what, in your view, has been the contribution of mediation in the dispensation of justice and the justice delivery system in India?
Can you hear me, please? Okay, thank you, Sandha. See, let me first begin by saying, over whatever experience I've had, it is often said that mediation is the alternative dispute resolution mechanism. The courts are burdened with very many cases, and therefore it is necessary to utilize this pipeline, which is one aspect of the matter. But I think the more important aspect I found is that the solutions which mediation gives, especially in family matters, is something which the courts can't resolve. Similarly, even in business disputes, I've had opportunities to refer matters to specialist mediators. I did it in Chennai, where a group fight was occurring between parents, a huge group. And at a very initial stage, we were able to persuade them to try for mediation. Sriram Panchu, in fact, did the mediation. And they were able to resolve something which I think the next 10 years could not have resolved with each running for the other. So I think one important aspect is that the mediation has brought the ability in our country to resolve certain nature of disputes, more family but other business disputes, in a reasonable and amenable manner. I think that's the first contribution of mediation. It has assisted, secondly, the courts in closing those issues, because at times, even if things are not resolved through mediation process, they are bridged to a level where it is possible for the court to do the last bit to foreclose that issue. It has slowly permeated. It needs much more to be done, honestly, I feel, because there are some states where the mediation movement is far more prominent. Delhi, Chennai, Bangalore, but in many other states, it needs to catch up to deal with the issue of resolving disputes in an early and better manner. So I think what I would flag is a better resolution of disputes. Number two, the ability to take it out of the main channel of dispute resolution and resolve it through this process. Also, I think the persons who train as mediators, it's, I think, an improvement in our personalities which is important. I trained as a judge, mediator in a sense, not formally taking a certificate but participating in every training program with the others. I personally felt as a judge, it helped me judge better. To me as a judge, that's one of the most important things. I was very reluctant and tough on the issue of letting anybody else have a say in the court other than the two lawyers. I thought that prolongs the discussion, but after going through a process of mediation and training, I realized at times the litigant wants something to be said, and maybe or maybe not the lawyer is able to fully communicate that to the judge. Sometimes, not always, giving those parties before us that couple of minutes to say what they want eases the pressure on them and the satisfaction to them that they have been able to say what ails them. We have a legalistic view of setting forth what ails the party through the lawyer. But actually, the trouble may be somewhere else, and I think in the mediation you would have realized so many cases, and Sadhna has handled them, and I always give the example of the case where she was able to, in a proceeding relating to custody, get the two parties together to an extent that they remarried. So issues where the pulse of the problem lies, and what is the solution to be found. Similarly, this is simply made two combatant business rivals into collaborators merely by judging from the principle that in an infringement suit, the party would found that there was dilution of the brand because the quality of the brand was extremely good. So the one infringing became a supplier. Now these are innovative methods. So what mediation gives as an innovative solutions is not something I think the litigation system can do. So if we can find these solutions, I think there's a far better method of finding solution.
Yeah. I think the next question is Justice Sikri. In your Lordship's view, what is the real difference between justice through litigation and justice through mediation? With your vast experience as a judge of the High Court, the Supreme Court, and being supportive of mediation since the time of its inception, could you give us some examples?
Okay, good question, follow-up question to what Justice Call has already laid down the foundation. Let me tell you, when mediation started in this country, and we know where we have come from 2005 after 17 or 18 years in 2023. I still remember the date when pilot project was started in Tisazari courts, and lawyers opposed it. They damaged the center when Chief Justice of India and many Supreme Court judges were coming to inaugurate. From that day, when we see today, and the journey in these 16, 17 years, it is remarkable. There is a total change in the mindset. People want to go for it. It's not only the advocates, it's not only the judges, and I'm very frank in saying that even judges were suspect in the beginning, and even the litigants now know what the mediation is. You see, initially what I'm saying is that reason was when it was introduced, and the perception was that look, courts are flooded with litigation, dockets are overflowing, which is the position even today, and therefore in order to ease the pressure of the courts, it is better to have this alternate dispute resolution. And as was informed to everybody, me and Justice Kaul were, when the mediation center started, the Samadhan started in Delhi High Court. We were there, put in by the Chief Justice. The committee was contributing from day one. And within a year or two, and after joining those training centers also, or training programs also, I realized that, which Justice Kaul has already mentioned, that looking into mediation from this angle, that it is only to ease the pressure of the courts is wrong. And many examples came which demonstrated that, in fact, the mediation under many circumstances, in many situations, or rather I will say most of the situations, is the better form of access to justice. And since you have asked me to give some examples of this, there are number of examples, one which is already narrated by Justice Paul. Let me tell you some stories and then what was the impact of these mediation, and these are real stories of mediation success stories. I remember I was sitting as original side judge in Delhi High Court. A very peculiar case came before me. It was a suit filed in respect of right on the ashes of a person after he had died. And the dispute was this kind of dispute which I think nobody heard it earlier, and I don't think any such case has come even thereafter. There was very famous author, O.J. Vijayan from Kerala. He died. And at that time, his only son was in America. His wife was in Hyderabad and she was ailing. And he had one brother. The state government decided to give state funeral, and he should be cremated with state honors. And only brother was available, therefore that brother performed the last rites. Now, brother and this O.J. Vijayan had fallen apart for last few years. They were not on talking terms, and because of that reason, naturally son and the widow, who had become now widow of O.J. Vijayan, they were also not on talking terms. Since he performed his last rites, the question was, by that time son comes to India, who should immerse the ashes? Brother said that, look, since I have given part to the fire, so it is my right. Son said, as a son, it is my right. And this was the dispute which I had to decide. Ashes were still lying, they were not immersed because interim order was passed, nobody would, and the case was pending when it came to me. I tried to tell both of them that why don't you settle the matter, they didn't agree. Both sides were taking hard position. Matter was argued. Of course, some literature was shown to me. I myself looked into our Vedic literature, our religious literature as to who shall have the right. I came to find that it is the person who gives fire to the last time and to the fire, that he has the right. And therefore brother had it. But I said the son cannot be deprived of, because son normally under the law has the right. So I passed the order that brother and son both would go and will do it together. It was not acceptable to the son, they were being appealed. When appealed before the division bench, matter was referred to the mediation. Now, I'll tell you the name of the mediator a little later. It comes before the mediator, and what mediator does, I should really admire the prowess of the mediator, and the manner in which she could understand the psychology of the persons. And what she came to know during discussion, which never happens in adjudication or in litigation, that look, as far as this son is concerned, he had actually his childhood, when both the brothers were on good terms with each other, he had spent his childhood with his uncle. And you know, in our society particularly, and there was not much difference of age, maybe about 8 to 10 years only. So at that stage, naturally, the uncle and nephew, they are best pals. So she just reminded them of those times, and both then started discussing. Both became emotional. As she told me later, she left the room at that time. She said that you talk to each other. and I'll come after 5 minutes or so, you just let me know. After 15 or 20 minutes, they call her. Both were crying, both were hugging each other, and the son was saying that after the death of my father, he is my father. We now remember those days and why we had unnecessarily fallen apart. And brother was saying, I never married. I think that was it. So he is my son. And they said that we have settled, both of us will go and immerse the ashes. Matter was settled. What is the difference? I gave the same decision, which they ultimately agreed. The difference is that my decision was not accepted. Number one. And most importantly, even if there was no challenge or had my decision been upheld, they would have gone, they would not have seen each other, they would have just performed those rites and then would have parted ways. But this mediation was able to rehabilitate the relationship. And hats off to Sadhana, who is sitting here. She was the mediator.
So this is really a very peculiar example of a dispute that got resolved through mediation. But as you rightly said, Your Lordship, that forcing a decision by somebody will never be acceptable. Perhaps if you write the same decision, the parties themselves write the same decision, that is much more effective and it goes a long way. Thank you.
This was an example how, I mean, if you want, I can give more examples,
Yes,
but then
know,
I think
know.
let us proceed.
That's true. That's true. Sadhana, please.
What Justice Kaul and Justice Sikri have said very significantly, particularly Justice Kaul saying that apart from other things, of course he's one person who's attended more trainings than any of us, either from 2006 or now, or, I mean, that said, he feels that he's able to do justice better as a judge. He's able to feel better as a judge after those trainings. And Justice Sikri significantly saying that it's not about mediation taking care of the court's dockets, no. It's about mediation being the best way. Having heard these significant points made by both Justice Kaul and Justice Sikri, my next question is to the Attorney General. Now, sir, this shows that Section 89 has been working quite well. Section 89 of the CPC, which is the only legal provision that gives the court the authority to refer and for mediators to mediate. In your view, now we're going to have, hopefully, a standalone mediation law. So with Section 89 having played this role, how do you think, how do you envisage a new mediation law or a standalone mediation law improving the role of the lawyers / mediators?
Put it so. I mean, not only here, elsewhere, throughout the world. Probably historically it was necessary that we had to do this travel. Socially unequal issues. Then other social, political, economic problems to be resolved only through the medium of rights, and therefore we have an adversarial system which is indispensable. If you have to move away from both these dimensions, the essence of mediation, I suppose, is not looking at claims, rights, but looking beyond that. But there is a need for having justice in a given situation. I look at Section 29 as a very small tool. It must have served its purpose over a period of time. But if it was so adequate, probably we don't need a mediation law at all. At the same time, we look at many of those legislations which were designed as social welfare legislations and with very laudable objectives of dealing with socially, politically contentious issues. Sometimes they become fetters on what really justice needs can be addressed. They draw a roadmap, they tell you this is all what the law will do, and you sometimes get caught into the framework of the law. Whether it is a SC/ST across legislation, we can have some examples, like, or even the bonded labor legislations. I've seen some cases come in Supreme Court. So between these two, the need for a new legislation taking the small little kernel of mediation principle in section 89 and two important, I think, pickup I can say from the two honorable judges. One, the possibility of an innovative justice. And the second, at looking at the substitution of access to justice, not necessarily through litigation, but through mediation. If only the law can catch these two fundamental principles, I think we would have moved forward a little. But more important than this, I think I still have problems with years of practice in different courts. The adversarial system will continue to drag us into those dimensions where administration of justice or doing justice will always be problematic, and one can always say that, well, justice has not been finally done. So the quantum of disappointment in the outcome of justice administration will always remain because of the adversarial dimensions. So I suppose if the mediation law can look at it a little more closely, and if over a period of time, incrementally, if the element of adversarial system in all tiers of doing justice, if they can be slowly, gradually eliminated, and then you're not talking about a mediation bar as a part of the bar. The whole bar would have become a mediation bar. I'm looking at a bar which is a mediation bar, not an adversarial bar within which you will have a small mediation bar. Because, you know, the origin of legal aid in a country. Legal aid lawyers who looked at little lower down the hierarchy and the quality of lawyering. I've seen that. I just recollect one small incident when, as a student of law, when Professor Menon was used to go in the Government Law College in Pondicherry. Every Thursday was a legal aid day. So one of the small cases, the old woman had a issue of revenue certificate to be rectified by the Tahsildar, which he was not doing for a long time. So as a very adventurous young law student, I cycled the next morning to the Tahsildar's office and told him, I'm coming to the law college, I'm a student of so-and-so, and why are you doing this? He looked at me and said, who are you here? That's the first question I confront. Somebody, therefore, an authority can confront you even while we have the noblest of aims when doing justice. So I went back to Professor Mann and said, what do I do here? I'm confronted with an authority. He said, go back. Take the woman along with you. There's an emotional element involved in it. If you can look at that question, probably you can solve that problem. I did that. By next morning, I think the certificate was given. But therefore, the emotional element in every one of us, look at my authority, your power, this, that, etc. All that always will play in an adversarial system. You can never avoid it. Therefore, when I said we have gone too deep into the jungle of rights, on the one hand, they are necessary, because many rights are necessary for resolving the most controversial kind of issues we have. But I suppose if the rights issue can be converted into a mediation issue, I don't know how we can do about it, but that's a very broad reflection. I can be very naive on that, but I suppose we can certainly do that. So let us look at the mediation bill from this point of view, and if can any element of this non-adversarial dimension get built into it, let us try to do that.
Thank you, sir. I'm so happy that you raised the issue of the emotions, because in mediation, we say, of course, there are cases which should not come to mediation, where we need a legal precedent or judgment is required, etc., etc. But including commercial matters, 95% of the dispute or the conflict is emotional. And we always feel there's no court in the world that can address those emotions. And those emotions have to be addressed for a complete solution. So thank you very much for the answer that you gave us.
I think now we'll turn to Justice Manmohan. Samadhan was started in 2006, when your Lordship was still a lawyer, and I think in 2008 your Lordship was elevated to the judge of the Delhi High Court. Your Lordship has seen Samadhan. It's a blend of the bar and the bench. How do you think Samadhan has evolved over these years? Because you've seen Samadhan as a lawyer, and you've seen for so many years as a judge of the High Court.
I'll tell you something very interesting. Last year, we had a program at Manasa. So on Sunday morning, we had called one of the honorable judges to preside over the session. He arrived a bit early, and we were all having breakfast at that time. When the learned judge arrived, first of all, he was surprised that in a hall of comprising of about 75 people, there were 60 lawyers and about 7 judges, and all were having breakfast together. Then the session happened. He participated in it. At the end of the session, he told me, "I'm very surprised. Here the lawyers not only participate in the sessions, but they promote the cause of mediation." He said in his state, there was a major problem. There was stiff opposition to the concept of mediation. And he said that he would like some lawyers from Delhi to go and address his state. And this was despite the fact that some of the best proponents of mediation came from his state. Initially, as Justice Sikri and Justice Kaul said, even we had some issues. But over a passage of time, they have got to be resolved. And I think the bar played a very positive role, especially the bar president then, Mr. Chandru. And an oversight committee was created and a few baby steps were taken. I don't know whether Sadhana ji you recall or not, but I was a lawyer at that time. And I remember doing a matter before Justice Swatantra Kumar in the extension block. And one day it was past 4:30, and we were requesting the learned judge that please wait for us even after 4:30, because we are entering into a settlement and our parties have come from abroad. They would like to go back tonight. So please wait, we are finalizing our Order 23 Rule 3 application. And it was past 5 o'clock, and I still remember the courtmaster telling us that you have to vacate the courtroom. Why do we have to vacate the courtroom? They said there is a mediation hearing here in the court hall. So imagine those days when we did not have any infrastructure, and they were using the court infrastructure post 5 o'clock for a hearing. And naturally, because confidentiality is involved, so we all had to vacate the room at 5 o'clock. And see, from those baby steps, from one small room, today we have one entire floor in the administrative block. We have 2 floors in the extension block. We have something like 300 mediators who have been trained. We have counselors. We have a children designated room. So giant strides have been made. And it's still a concept which is catching on. I don't think it has achieved its peak at the moment. And there's a lot of work to be done, but I think the bar is supporting the cause of mediation. Even today, let me tell you candidly, though I am the chairman of the oversight committee, but we don't minutely oversee this committee. It is done by the lawyers themselves. all decisions are taken by the lawyers themselves. In case there is a policy decision or some issue on which there is some opinions which have to be sorted out, then only we intervene. Otherwise, we allow the lawyers to take the decisions. And it's a complex affair. There are about 120 matters which are listed on a daily basis. How it is to be distributed, how it is to be done. They are virtually handling the burden of, say, 2 original side judges on the original side today. So it's a huge burden which is taken over by the mediation. And they are giving very good results. And as Justice Sikri and Justice Kaul said, there is a finality attached to those orders. Today a single judge decides, it only leads to an appeal. What they do over here is they permanently resolve the issue. So that's a big thing. I think the bar is very cooperative. They have taken the lead in this matter, and we are very grateful that they have taken the lead. Because without the lawyers' help, this really cannot move forward. So I see great prospects for mediation, and the way the bar is helping us, I have no doubt that we have yet to reach our peak.
Thank you, Mr. Bondan. In fact, this reminds me of some of the judges visiting the mediation center and actually seeing a live mediations being conducted, and would encourage both the mediators and the parties, and that itself gives us a lot of confidence to the mediators to sort of take this movement forward. Justice Kaul, as you know, that the process of mediation begins from the court, and the role of the referral judge becomes very important. So, how should the referral judge prepare the parties before sending them for mediation? And what, according to you, should be the ingredients of the order? What should be the contents of the order?
See, let's keep in mind one thing, that this mediation center is, I call it unique in its own ways. Unique in terms of a collaborative effort of the bar and the bench. A trust the bench had that the bar would be able to do it, and the trust which was justified, as it was said on appeal by the Chief Justice of our High Court, Mr. Chandiok, said you won't find the bar lacking. So when you're talking about, there are 2 roles. One, a mediator performing his role in mediating, for which he goes through a training process. We've said a number of times, don't say that you don't require a training, that everybody has a mediation innately, that mediation has been traditionally in India, that we've been doing mediation from Lord Krishna's time. Clichés are nice, but the point is that you have to develop your skills today in anything. Similarly, when we talk about a judge making a reference, I think it's equally important for the judges to go through a process of training. So if you see across the country, many of the courts, the judges have themselves invited mediation trainers to take them through the process of a mediation training. In different nature of litigations, there are different stages at which matter may be amenable to mediation. So the judge must have the pulse of whether a particular mediation stage has been reached or not. For example, my own view is that in a suit proceeding, a very good time, both by our experience and experience of other countries, is when parties have filed their documents, issue settlement takes place. When you send them for trial, that is the stage where you give them a hiatus period to mediate. Because both parties know their strengths and weaknesses by that time. They know what documents they have to support their case, the lawyers would also be supporting it. And yet, there is this trial which must hang on their head. That either you settle or you go to through a process of trial, depending on whatever your strengths or weaknesses are. So I think that's one important stage which on the original side the judges can utilize. There are times when the matter goes through original side and appellate side both, and comes to a stage where litigation fatigue sets in. Now the judge must be aware, is this a case where litigation fatigue is set in? But then there must be a preparatory work done by the judge for that mediation to take place. In that preparatory work, sometimes, of course, the mediator will introduce the process of mediation. But when the judge sends the matter to mediation, if he gives a little introduction to the parties, calls them and tells them, look, this is what it is, this is how it will be useful, I think it helps the mediation process and helps the mediator also in proceeding with it. So one of the fears which parties have, this is some concept of derailment which takes place. So you will derail this process, the court will not decide. The court must therefore fix a date, both before the mediator, which we always do, that okay, when will you appear? And give a reasonable time for the mediation to work out, which we normally believe, at least I believe is about 2 months' time, should be. And then fix a date for the mediation report to come back. So the parties have this confidence that it is not that something will go out of the system and then will be another challenge to bring it within the system. So the judge must control it in that sense. I think even the appointment of who is a mediator, though in a place like the Samadhan is left to them, it is they who are to see, because depending on the nature of matter, there will be different kind of expertise which mediators will have. We have seen times when at times some judges would call for and say, please give us if it's not successful, let us, the mediator, explain what has happened. And then some of us would go and explain to the learned judge very politely that this is not how it done, it's a confidential process, so we can't tell you whatever has happened. Sometimes, yes, when parties come back into court, their lawyers, or they may say, look, we were very close to a settlement and it fizzled out because of this point where the judge can take it up. So this is another aspect the judge must keep in mind, to be in control of the matter, explain the process, and then send the parties saying, look, you work it out well and good, otherwise you come here. I sometimes also believe that some kind of the inclination of a judge as to what can be worked out or finding that sixth sense helps. I can only give one example where there's one of the principalities of Maharashtra where these two parties are fighting. There were children of two wives, and when they came to court, and this is an issue why I am giving an example is because wherever real estate is involved, the cake has become larger over a period of time. So judge must explain that, look, you may be wanting a larger share, but even if you achieve a lesser share from what you would have got 10 years ago, in a better area. So both the parties, they asked them that, have you ever discussed between yourselves? This is the third or fourth year. They said, no, we've not talked to each other. So I said, how long? They said, about 20 years we've never talked to each other. So I said, do you mind if you come back tomorrow and go for a cup of coffee today evening and at least try to see what could be done? If the matter couldn't even have been required to refer to mediation, but the parties themselves worked out the whole thing to a substantial extent, and then whatever the suggestion was from one of the parties, the other accepted. At the end of it, I told them that, well, now you can have something better in the evening after you've been through this process of settlement. Because the cake had become large. So it depends where real estate is involved in a solution. Where family is involved, you have to bridge the gaps. And if the court, I think, bridges the initial gap a little, gives the confidence to the parties, stays the other proceedings which may create a problem, we can solve, especially in matrimonial matters, there is always a bouquet of cases, I call them. It's standardized. Due respect, the legal fraternity introduces them to this large number of cases in the process. And the court must keep in mind that sometimes it arises because parties have not talked, which is the most important thing. I'll only say this in one of the oldest suits which came before me, I think it was 1970s suit when I was playing. It appeared the parties had not talked to each other at all. Mr. Chandiok was one of the counsels there. I said, can you just come and discuss? Between themselves, I said, let them all come from wherever part of the world they are, but for 10 days they must come and do so. It finished off, they came before me. One of them raised the hand and he said he wanted to say something. They said, no, don't say anything. I said, doesn't make a difference, what does he want to say? He just said, I wanted to say thank you because we had not met. I can assure you that thank you I still value more than any intricate judgment I would have carved out of it.
I That's really encouraging to know that your lordships of the view that the parties should be actually prepared by the court from the beginning before they're referred. And don't you think that nature of the dispute could also be implicated in the referral order? Because ultimately the person who marks the matter to the appropriate mediator should have a background of what is the nature of the dispute.
Yes, maybe there are two ways to look at that situation. One is that if you start indicating what the dispute is, sometimes the party may get apprehensive.
Correct.
Why is the judge telling down what the issue is, and is it indicating something? That's the challenge. But my personal view would be the matter by its very nature in a high court would be marked already as a partition suit or as a matrimonial matter or other. And when it is sent, maybe in the sending process, it should be so marked so that the marking person who has very large cases knows what is the particular subject matter it is,
right,
and give it. I mean, I have from Supreme Court recently, I think a couple of days back, they said it's a little ticklish matrimonial matter. So I said, look, I don't know her. I can send it to the Delhi High Court. I know some people who are there. I think I appointed Veena as named her as a mediator and said, I told the party, look, she's a trained mediator in matrimonial, so please go there and go today itself at 2 o'clock.
She's used to handling ticklish matters.
So that's the way I think it can be indicated. Because sometimes my only view is if we start penning down something, the party should not get influenced.
Right, right. Thank you so much. Sadhana.
Now, an important question for Justice Sikri. We've always admired how you had the foresight in 2019 when you were sitting in the Supreme Court as an honorable judge in that M.R. Krishnamurthy versus New India Assurance to recommend a mediation law for India. Apart from your recommendation for what we know as MAMA, the Motor Accidents Mediation Authority, apart from that, you also recommended a standalone mediation law. Now that India has signed the Singapore Convention, which mandates a domestic law for the purpose of ratification, we all want to know from you, sir, what would be your suggestions on the nature of this proposed standalone mediation law for India?
Actually, I think I proceed from your earlier question you put to the Attorney General about Section 89. Section 89 talks of some alternate dispute resolution mechanism, which includes arbitration, also mediation, court settlement, even that is there, lok adalats, etc. Mediation there is only mentioned as one of the forms of settlement. And so this is court annexed mediation. Naturally, case is pending in the court. And therefore, the court thinks that it is a fit case for mediation for so many reasons, and it should be, the parties should make an attempt to resolve the dispute amicably without there being an adjudication, and therefore the case is referred. If mediation fails, it comes back. But then, what is mediation? How mediation is to be done? What are the rules, the procedure which is to be followed? A mediator, what is his responsibility? What are his functions? Like under the Advocates Act, for advocates we have code of conduct, code of ethics. All this is not prescribed, obviously, in Section 89. And if the settlement takes place, of course, when the suit is pending and under Section 89 matter is sent, the settlement in the form of settlement which is recorded, that would come back to the judge, and the judge can pass a decree in terms thereof. That is fine. But mediation under Section 89, court annexed mediation was the first step taken by the Parliament in spreading the mediation movement in this country. If you see in other countries, and many Western countries, particularly American example, where before even going to the court, the parties think that they are trained mediators, they have their offices like arbitrators, etc. There would be an agreement, let us go to Mr. Chandok and let us have his services. If the case is not settled, then we'll go to the court. And if they go to him, 2 months, 3 months are spent in this process. In the meantime, suppose the limitation is expiring, what would happen? Because it is a process which is consensually agreed between the parties with no legal backing. All these aspects have to be taken care of, and therefore Mediation Act or mediation law is required. Insofar as Singapore Convention is concerned, that talks of international disputes, cross-border disputes. Suppose there is a dispute between a company, because it mentions about commercial disputes, so I am giving that example, between a corporation in India and a German company, and they decide, let us have the settlement, and they appoint a mediator who is in England. Settlement takes place. Under that settlement, something is to be done by Indian party, some to be done by the German party. And suppose the Indian party doesn't do that. So whether that would be enforceable in India, mediation, for that law is needed. So for that reason, Singapore Convention was signed, which contains all these provisions. And that was a reason, of course, even before Singapore Convention was signed. And from our experience, when we were here and we used to talk about this mediation, and we knew that mediation is not to remain only as court-annexed mediation, and there's a time has come that it should spread its wings. And I always feel this Samadhan in that process is through Madhyam. There has to be a Madhyam to arrive at Samadhan. And I admire this move on the part of Mr. Chandok, Sadhana, and all those of you who are sitting here and have started this Samadhan, this Madhyam. So obviously this is the purpose. So, and when this case came before me, and although it was a case of motor accident, and where it was found that it had taken such time in that case, and in that particular case, the lawyer had suggested about that mama, not chacha, and that was incorporated. But I then found that it is the right time to at least send a signal to the community at large and public at large, and even to the government, that we need Mediation Act for so many purposes, some of which I have already indicated. And I am happy thereafter this Singapore Convention was signed, and India was one of the first signatories, very first signatory on the signing ceremony itself, which took place in Singapore. Indian High Commissioner there, he signed on behalf of India. And but only thing is that although within a year or 2 years maybe, as far as Singapore is concerned, it brought its legislation, but in India, Mr. Attorney General, we are still waiting for bill has been passed, a bill has been presented. Of course, as I know, Justice Kaul knows, in the Supreme Court MCPC, I was the chairperson. Now, thereafter, Justice Kaul became the chairperson. I started the process, but then he finished. The bill has been prepared by MCPC. It was sent to the government maybe more than 2 years ago. Yeah, more than 2 years ago. And I know that Ministry of Law also, they also came out with their own bill, because it was after my retirement I got a call from, that is also now more than 2 years, it was COVID had started, I still remember COVID period when I got a call from law minister that there's some MCPC which of the Supreme Court has sent the bill. There's some bill prepared by the ministry. There are some differences. So if you could give your inputs. So I'll send the law secretary, of course, on Zoom only, that law secretary who's now your judge. We discussed for 2-3 hours on that and tried to iron out much of the creases. But unfortunately, there are some problems because of which I need not say in detail here, because of which it is not getting through. But it's high time that Mediation Act needs to be passed if we really want. It's not only in our Indian context, but internationally also. When we really want that India should be known as country for mediation, we have lost out. At least initially. Now let us see what happens as far as our arbitration is concerned. Landscape insofar as cross-border or international arbitration are concerned, we have yet to make a mark. But we should not lose out on mediation. Let me tell you, I can say here, not as on behalf of what is happening in entire India, but I am proud of this Samadhan. The kind of commitment, and this was the first the question put to Justice Manon as to how it has come. But I only say the kind of commitment which I have seen, the kind of honesty of purpose which I have seen, the team here, and all these persons, even after 15, 17 years, they are even today doing it with same zeal, same commitment, and same sincerity. That is one reason. And not only when Justice Manon mentioned that one of the judges of the Supreme Court came and he said that why your team doesn't go to our state and does this, spread this kind of moment. It's, if Justice Kaul would remember, and Sadhna, you, Mr. Chandok, Mr. J.P. Singh would remember, even when those initially, we didn't have our trainers. So when it started, so we used to have trainers from other states, but when they would come and they would see the kind of bonding as that at the breakfast, what that the Supreme Court just saw, which had always been when we used to go there, he would Mr. that from Gujarat, Mr. Ranjat Bhatt, he would always say that I want you and Kaul should come and become judges of my court and do something here. The way the judges are supporting mediations, and that is remarkable.
That's the reason it's all
right. But I would give all credit to the bar, as Justice Kaul has given, because of our own we could not have done anything, and you are still committed and wedded to this cause, and you deserve all this. But then anyway, I've reflected, but in the coming back to mediation. And I remember, and Justice Kaul would vouch for it, that he told me when this was mediation bill was being drafted by MCPC, I think persons from Samadhan or Madhyam gave their inputs and all their experience, etc. was it is found in the it can be found in the bill which is prepared by MCPC. But high time, I think, just impress upon the government whichever way they want to do, but take it, whether it is arbitration or it is mediation, it has not to be controlled by the government. That one line, if one message goes that these are to be autonomous bodies, they have to function of their own, and I think problems will be solved. And I think you know what I mean and what I am conveying. Thank you.
We will also look to the Attorney General, to the learned Attorney General.
When we sent the bill, the response from the government
Now, sir, to you, the Attorney General, sir. There's one, of course, you've addressed about mediation bar, you did talk about it. But this is a very specific question. Do you think that mediation bar will be the natural outcome of the mediation legislation? In this context, how important will it be to train lawyers in mediation advocacy? You did address on the mediation bar, but I think this is a little more specific if you could throw some light on it.
Let me look at it like this. So you have a principle of law which we pick up. I go to the roots of the principle of law and train my mind how to look at it. That's how the legal system guides.
Correct.
Sometimes one principle of law is so pervasive enough that we forget other principles of law. When we talk of equity. But many of us who belong to a generation of law students 30, 40 years ago, we never had an exposure to an idea like this. We thought we look at a law, go to the court, litigate, and get a maximum output for the party whom we represent. Therefore, we became partisans always in a battle. So the element of being a partisan is so deep-rooted in our system, in our study of law. So probably we have to start from our law schools.
Correct.
I'm sure that the mediation will make a difference in understanding the whole concept of rights and claims and interests and how we look at certain principles which have contributed to entrenching certain notions. So if through the mediation law certain entrenched notions of doing justice through, again, an adversarial process, you were able to eliminate them over a period of time. That's the mediation law would have served the purpose. And I'm sure it can serve a purpose. But again, it requires a lot of institutional supports. If you have to depend entirely upon the court system to evolve this very wonderful principle to the mediation law, it may take a little longer time. Because again, we have a diverse set of courts in our country and diverse set of socio-economic backgrounds and different regions and things like that. So probably we need to require some institutional structures to strengthen the hands on a mediation law to achieve these purposes. And to that extent, maybe we need to put into the mediation law whatever the additional dimensions may be required. But just by way of information, I wanted to tell you, I understand the ingenuity of the organizers today calling me for more than one reason. Of course, I spent, we have sadhana, we have spent a lot of time not only in our chambers, but while we used to visit several law schools, and some of these very important principles of taking justice beyond the current borders of doing justice. So the first step I thought I must do is to, I called the law ministry to tell me the data on litigation pending on different kinds of cases and categories. So I picked up the service law, for instance, people going to court for pension and things like that. And so I had asked the government, I said, let's evolve a model of mediation at an administrative level. That there be a nodal officer in every department who should probably report to me before a litigation is taken to the court as to why they cannot resolve it through a mediation. This idea is being slowly driven into the minds of the government. And suppose if in one domain of litigation, if this can take root, so an administrative mediation culture also will contribute to a great extent on the assistance that the court will then get in mediation. If we have a completely closed mind and adversarial mind at the administrative level, then the assistance on mediation culture in the court would also be problematic. So I think therefore we need to address the different levels and different tiers of assistance both to the courts and outside.
Thank you.
That's how you look at it.
Thank you, sir. Justice Bhavan, as you see, a large number of mediators of Samadhan who attended today. We'd like to hear your views on how a mediator should conduct mediation that is referred to. Very briefly, if you could just 2 minutes throw some light.
Whenever I have an occasion to speak, I always say that mediation is like a science, or you may call it an art. But a mediator is like a doctor or an engineer. He has to follow certain techniques, certain formulas, certain processes. See, as Justice Kaul also said, that just because you are a good listener would not make you a good mediator. See, there is a lot of debate, even amongst mediators, which is the best way to resolve a matter. See, some people believe it's the facilitated method, some believe it's the evaluative method. But in Delhi, what we follow is the facilitative method. And what we do is we assist the parties in finding a resolution. We don't force a decision. We try to resolve the conflict by addressing the underlying cause. Take a simple instance like when the matter is referred to mediation, the court file is normally not shown to the mediator. So what he does is, an opening statement by the parties, he has some doubts, he'll ask them, whatever doubts he has, he gathers some information. He may suggest a large number of alternatives which may be available. Then he expects the parties to move from their stance or their viewpoint that they have taken into order. They have to move from their positions, they have to shift their positions. That is very, very vital. In fact, some of the mediators, because they are lawyers, they give their opinions, or they may honestly believe that this is the best way forward. They start insisting that this is the best way forward, let's move with that. That's not the role of a mediator. That may happen in court, but not here. So, it is court assisted, it is an assisted mediation. And what we do is we give privacy to party autonomy and to self-determination. Because we want to address the underlying cause, the root cause, and not deal with it at the surface. Many times parties point out to a difference in court which may not be the underlying cause. And when you speak to them in private, they may say, no, this point that we have raised in the proceedings, which you are trying to deal with, is not the actual cause for which we have come. And that actual cause may not even be highlighted in the petition. So, the process is a very scientific process that will have to be followed. And it's those formulas, those techniques which normally the Samadhan tries to teach you during that 40 hours training that they give. That's the starting point. But I think it is important. And please apply those techniques, those processes. Without that, I don't think we will be finding a solution. That's the intent, to address the underlying cause of conflict.
Thank you, Justice Manmohan. We have instructions from our organizing secretary to quicken our process. We don't want to miss out on any question, because when are we going to get this panel again? So we'll try to be brief in our questions also.
We'd like to wind up with beautiful prose or a poem written by
From
the Attorney General. I think I just read it, and I think we should end with that. Of course, you can go ahead with your questions.
Is that about the umbrella?
You'll hear it in a while.
There's a beautiful one he's written about the umbrella, the role of the state, the leaking umbrella. Very briefly, I'd like to ask Justice Kaul. Sir, you have seen mediation. Justice Manmohan has talked of the process. We've talked of everything from the mediation bill to Singapore Convention. But there's a vital aspect for a mediator, and that is the ethics of the mediator himself or herself. There is no advocates act, as Justice Sikri very aptly said, for mediators. We have to have our own. So, could you give us very briefly what should be the ethical dimensions that a mediator must follow?
See, to my mind, the ethical dimensions are no different than for a judge. Sometimes they used to earlier say in a very colloquial sense that a judge should be a gentleman if he knows a little law, it is not his qualification. So the idea is you must be a gentleman. What is a gentleman? It carries everything within it, a lady or a gentleman. And the parties must be confident that what you are doing is not without any motivation. Therefore, the Samadhan also keeps a check on it, keeps a feedback on it. He must realize his neutrality is most important. Yes, his ability to listen, his ability to have caucus sessions. How do you have caucus sessions if there is no confidence? Tomorrow, the other party may start suspecting. So he would have to lay down the groundwork, explain how a caucus sessions are held, and how he interacts with it. And that's a reputation you build. There are mediators who build their reputation over a period of time. There are mediators who spoil their reputation over a period of time. And that's why sometimes we've had difficult decisions to keep off people from mediation. So I think the ethics requirement is a simple issue of neutrality, coupled with the ability to listen to both the sides, help them in arriving at a solution. Of course, it's not a very hands-off approach of a mediator. Yet, it should not be an extra hands-on approach where you are trying to force the solution down the gullet. That's not how it should happen. So, ethical way, I really don't think there's any difference of what my expectation would be of a judge, of an arbitrator, a mediator. Yes, you are right, there are no norms. That's the as and when the government condescends to bring the act into force, those aspects are also taken care of in a sense. So, that's what I would like to say.
Sorry, Sadhana Justice Pratibha Singh wants to have one question. I'll just pass on the mic. She has one question to the panelists.
Good evening. It's a wonderful panel. I just wanted to add one thing in one sentence. Last year I had to write an article on IPR and mediation. And I called Mrs. Veena Ali and I had requested her for the statistics of mediation and intellectual property disputes. And it revealed an amazing statistic that the percentage of settlements in Samadhan in intellectual property matters is between 85 to 95%. So the number of cases which have been resolved, which have been referred to Samadhan, are so high, and they've all been resolved successfully. Thank you so much.
In fact, Pratibha had asked me, because heading the Legal Service Authority, to organize, when we're interacting, to organize a Lok Adalat of IPR disputes and try to see how many of them we can resolve. I fortunately or unfortunately am wearing both the caps of the NCPC head and the National Legal Service Authority. So it's easier for me to do this.
So Justice Sikri, now the question to you. You're aware that there is a process expertise and there is a domain knowledge of the subject of the dispute. Do you think that domain knowledge is equally important with process expertise? Because some people have different views on it. I mean, we're talking to mediators from different states. Although our view is, I think, what we've been taught by all of you, but we'd like to hear your views today.
Let me tell you one thing, and I think this is a basic thing which has to be kept in mind, and that would provide answer to your question. Mediation is one process where both parties are involved, correct? As Justice Kaul pointed out, that when he took the training as mediator, of course, not formally, but attending almost all training sessions, and even he's continuing even today, it made him better judge. he started becoming a listener, and he thought that let me give a chance to parties as well to speak out. What I'm trying to say is, insofar as mediation is concerned, it is party autonomy. It is those two parties who are at dispute, they have to come out with their solution. Having said that, another unique feature of mediation is that we don't say before the mediator only those two parties would appear. We always insist, and that is always required, or rather that is always proper, that the parties come with their advocates. Why advocates are necessary? It is because of the reason that they would be able to tell some of the legal nuances of the dispute. Because of that, mediator will be able to understand as to what the disputes are. As Justice Manmohan has just now pointed out, the process of mediation, of what mediator has to do is, from the positions which the parties have taken, we have to drive them towards the interest which they have in the dispute. So there is a difference between the position and the interest. And in order to understand all this, I think domain expertise becomes necessary, if I may say so. If there is a commercial dispute and I have no knowledge about commercial law, how would I understand? And there's one thing more, although I mean it has to be done by somebody else in the mediation process, which we call early neutral evaluation, ENE. Because this evaluation of the respective cases, merits of the cases, is to be undertaken, and the parties may say, go to a person that, look, we are thinking that A is thinking that he has a very good case, B is thinking that his case is better, but that before going to the court and testing waters, why not go to some person who would tell us who is better? It's a non-binding, but most of the time this task is also undertaken by mediator. When, after hearing the case, when he has caucus sessions, as Justice Kaul pointed out, during that session, he can point out to the party without other side knowing that these are the weaknesses or these are the strengths of your case, or particularly weaknesses, so that you don't take that hardened situation. How he will do unless he has a domain expertise.
Thank you.
So therefore, this becomes, I think for lack of time, I wanted 2-3 such examples also.
Yes, actually, I've been getting too many chits.
Yeah. So therefore,
it's now high time that we conclude. But this one last question, I think. We've been told to stop for the question.
No,
One last question.
No, the last question need not be asked because it's a kind of a repetition.
No.
Is what the...
This is the question.
Let me not...
Because I think that a lot of mediators
No,
have this, would want to know. The question, Your Lordship, is that, as you're aware, the mediators are paid nominally. And I think this both Justice Kaul and Justice Sikri and everybody, I think, on the panel must respond to, when they feel that they spend several hours, and there is a point where the parties should be made to pay. That's what they feel. But how does one make this workable, is the question that they want to ask.
Get the act into force. Private mediation has to take over a period of time. There has to be supplemental of both institutional mediation and private mediation. Even today, courts are referring cases to private mediations also, where there is an expertise required in a particular field. But to institutionalize it, to formulate it, the act must come into force. That's why the anxiety I have that if we want to take it to the logical conclusion where both private and institutional mediation go on, and mediators find that they can make some kind of a part living out of it, as in the US they do, then you have to have an institutional structure of an act which will govern both private and national mediation.
That was going to be my question. Yeah. Just one last question to the Attorney General about private mediation. And I think partly Justice Kaul has answered. I was going to ask the Attorney General. And this is one of the important reasons, as you rightly said, you are here, to answer that, in view of the impending legislation on mediation, how do you see, this is quote an ex mediation that we are practicing over here, how do you see private mediation, private practice of mediators developing in the advent of the new law?
Well, as I said, even in answer to your first question, I would certainly vote in favor of a private practice of mediation. That's the culture. The whole culture of doing justice through legal practice, if it had gone all along in a certain direction, why don't we encourage a private practice of mediation? But then, just talked about the compensation for somebody spending time to resolve somebody else's problems. And so look at all of them which are yet to be answered in an equitable way. Therefore, I would vote in favor of a private mediation part to begin with, and to
That's
acknowledge
very good
it,
to know, sir. That's very good to know.
and to acknowledge the importance. Its importance in promoting the culture of mediation as the noblest way of doing justice. Therefore, to sum it up, not the survival of the fittest, but the survival of the noblest. See, that is
so wonderful.
Oh, no, I thought specifically wanted to guess.
Now, I don't think we can ignore too many chits that are coming to us. We can ignore one or two, not too many.
This is a small piece I wrote while addressing some law school on mediation. I read it out earlier to Sadhana. I thought if it made any sense, let me share it with all of you. If I have to win your heart, give it to me free. No questions on price, no issues on terms. No exchange at length on matters to be resolved. Just give it to me free. If I have to keep it safe, just give it to me free. No doubts on lockers and their keys, no queries and lengths of keep, no documents to be scripted by law firms and their interns. Just give it to me free. If you want it to return as good good can be, just give it to me free. The birds will tell you tales. The grass will tell you how it swings with winds, have secrets for all hearts. If you want it raised to horizons all green and splashed with hues, where strife is an unknown book, just give it to me free. In giving free you will learn you have known all freedom rules.
If our time is up, then we thank our honorable panelists. And may I call upon Rajiv Irmani.
Justice Manmohan.
Oh.
I thought you were hurrying us
I
up.
thought, yeah, exactly.
Yeah.
We've cut our questions.
That's a vital question.
Getting slips saying that please don't ask more questions.
Please, Sarka, that first question.
Sir, I think it's only apt that we end with this. As chairman of Samadhan, what do you think are the challenges that Samadhan faces today?
Challenges are always there. The first challenge is that we appoint a person as a mediator after giving him 40 hours of training. Now, this is not like a government panel that you have done the training, you are on that panel, and you will always remain there. You have to continuously evolve. You see, there has to be continuous training, there has to be continuous feedback. There are a few issues which are there and very fundamental, and I think where all stakeholders will have to come together to resolve this. See, by its nature, mediation is supposed to be confidential. It's a very private affair. So when the mediator is handling the dispute, there is no third party in that. In a court, people are judged because it's done in an open court. When the mediator decides, he does it within a small room with the lawyers at the maximum of the parties. So, how do you know how he's treating the parties? How is he performing? As I said, it's a science where you have to apply certain processes, certain techniques. There is no feedback as such after taking the training, how you are performing. So the stakeholders amongst themselves will have to devise some mechanism. Someone may be an excellent lawyer, may have taken the training, he may not be a good mediator. So how do you handle that situation? That's a challenge which is there, which will have to be there. Secondly, as all the panelists have said, the mediation bar will have to be a dedicated bar. It cannot be a part-time bar. See, today, many times they say that the domain expert was not available to whom the matter could have been referred. Why? Because he was busy in court. He did not come to the center on that when the reference had to be made. Or he's gone to another center. He's working in district courts also. He's gone there. So, it cannot be part-time. You have to be dedicated to the cause of mediation. And really, that's where the bar needs to evolve. We have made giant strides, as we said, but we have to achieve quality, we have to achieve excellence. And really, we now have to focus on that. How do we take the next big leap? And this is the challenge which we have, whether we give them continuous training, whether we give them a feedback, how do we handle it? And that's really where the stakeholders need to sit together. The bench, the bar, the consumers of justice, and find a solution. And I think that would be the next big challenge. If we have to achieve ultimately the best quality and the excellent standards, especially with the signing of the Singapore Convention, with mediation being available, and a lot of international mediators will also try to ensure that the work from India comes to them. So there is going to be tough competition in the years to come. It will not be like court annex mediation and everything will come to the mediation center. There will be challenges, there will be competition, and we have to gear up for that. That's the next thing. Infrastructure at the moment is quite good, but surely there is room for improvement, and we'll try our best, whatever we can do within our limited means. But really today, I think at the moment, we need to expand a little more, but at this moment we can handle it. You're right. You're right. After all, 120 cases in a day is a challenge. I agree. But we all have to manage, keeping in view.
We have 152 and 122 cases on consecutive days. And I had the experience of seeing private caucus, private session being conducted in the lift where there was space.
It also shows the confidence the people have. The matter gets resolved.
I think we can continue for many more hours, but looking at the commitment of our honorable judges and our esteemed guests and members, we need to conclude it now. May I request?
Veena, there's a very important aspect which Justice Kaur has pointed out.
Please.
Last time we were here for inauguration of this.
Yes, please, sir.
The Minister was voluntarily glad. So I said that's possibly the only solution whether you need further.
I think we need to thank our panelists for such a informative session. May I request now JP Singh to do the honor and present memento on behalf of Samadhan family to Justice Kaur. Samit, आगे से। Thank you, JP. May I request now Maninder Singh, Senior Advocate, to do the honor to the learned Attorney General. Mementos on behalf of Samadhan family. Thank you, Maninder. May I request now Jatan Singh, Vice President of our Delhi High Court Bar Association, to do the honor on behalf of Samadhan family. All these are, sir, they are all trained mediators. To Justice Sikri. Thank you, Jatan. May I request now Mr. Rajiv Birmani, Senior Advocate, to do the honor to Justice Manmohan, our Chairman. Thank you, Rajiv. Now I will not let you go from here. Please present your concluding remarks. Thank you, Rajiv. Please start.
Let me assure you it will not be long. I prepared a long speech, but I'll keep it short considering the time. Honorable the distinguished panelists, Honorable the Chief Justice, Honorable judges, my colleague mediators, honorable members of the Bar Association, ladies and gentlemen. Good evening and Happy New Year to you all. It was a spectacular panel discussion that we had today, and I think we need to have it more often. This keeps our spirit alive. This is an encouragement to all of us. It's a reminder to all of us of our success and our failures, of what we need to do, what we need to improve ourselves. You know, the areas where we are lacking, areas where we have excelled. There has to be a reflection done periodically. Justice Kaul's views were very instructive when his lordship said that innovative solutions can be found in mediation. Undoubtedly, it is true. While sitting as a judge or arguing as a counsel in the court, you can only argue within the confines of the brief that you hold. But when you sit as a mediator, and I can explain to you, I have been a mediator ever since the Mediation Center was founded. There are innovative solutions that we have found, and parties have gone home happy. So that indeed is an achievement which can be realized truly through the process of mediation and not through a court litigation. Justice Kaul's views on what the judges should really indicate when they are sending the cases to the mediation is again truly instructive, and we would certainly look forward to receiving those hints in the orders where as mediators we know what really is involved in the dispute which is being sent to us. Honorable Justice Sikri's views on better form of redressal, undoubtedly, Lordship's experience is quite vast in the field, and Lordship has seen how the mediation, the resolution can take myriad forms and ensures rehabilitation of relationship, as Justice Sikri has pointed out. On Section 89, yes, indeed, it only gives us a handle to enter mediation room, but it does not lay down the process that needs to be followed, and therefore the need for legislation, which will set down various aspects, the rules governing mediators, the rules governing mediation, the enforceability of mediation, and the entire process. So indeed, we are looking forward to the new legislation which will govern the mediators. The learned AG's views on the on the litigation being an adversarial system creates disappointment is something we have all witnessed, we have all noticed. It only leads to a win-lose situation, whereas mediation leads to a win-win situation, where the relationship is restored and we've seen parties going home happily. Justice Manmohan views that baby steps were taken, infrastructure is created, and of course, giant strides have been made, which indeed is true, but we still need to go for miles before we can say that we have achieved something which is truly world-class. So indeed, we as mediators are working towards it. We spend hours in the mediation center on a weekly basis, all of us. And sir, we can assure you that mediators would take the mediation center, Samadhan, forward in times to come. Samadhan has grown from strength to strength in the last 17 years of its existence. I have some statistics that I can share with you, which I have taken from the mediation center. Out of 32,788 cases that were referred by the court for mediation during the period 2006 to 2022, 10,563 cases have been settled through the process of mediation, which is a remarkable achievement. If I can take some credit for giving those figures. Another 7,471 cases which were linked to these settled cases were also settled, though they were not specifically referred to mediation center. So mediation has that advantage, a unique advantage, where you settle one and several others are settled. I can remember one case where Justice Kaul had referred one case to us for mediation, and it took us, Mr. Dalip Mehra and I were mediators, it took us almost 6 months to implore the parties to tell them, please tell us what is holding you back. And then they came out with 18 cases pending all across the country. They were very reluctant to spill the beans, but we could persuade them to tell us those 18 cases that were pending literally from Jammu to Kanyakumari. We took another 1 year to persuade them to settle. We settled all those 18 cases that were brought by them, which were not in Delhi, but we could not settle the case which was referred to us. And the mediation center gave us a big zero. During that period, there was an assessment which would happen. For every successful case, you would get a point, and for every failed case, you would get a zero. So we got a zero. But we were quite motivated to continue with the process. In that matter itself, Justice Kaul appointed me and Dalip as early neutral evaluators. I think that was the first and only case of its kind in the country where ENEs were appointed. We tried our best. It was a unique process. We went to Justice Kaul to seek his guidance as to how to go about this process because we were not trained in ENEs. Justice Kaul explained to us the concept, and we actually did hold ENE sessions where both lawyers were invited. They presented their case, they argued their case, they cited case law, and then we gave them an opinion individually, telling them what is the respective strength or weakness of their cases, for them to evaluate whether they should continue with litigation or they should compromise. And our role ended there. But I think we are matured enough today in Samadhan to take on the ENE as well. So I'm looking forward to a training, all of us as early neutral evaluators, where we can, with our domain knowledge, sit with parties, explain to them their respective strengths and weaknesses, not in the presence of each other, but in caucus sessions, and persuade them to look forward to a settlement. Today, we are actually prohibited from expressing any opinion. Possibly, we can dissociate that role from the role of a mediator and assist them in arriving at a conclusion in their minds, whether they should really look at a solution rather than face a verdict from the court if they are not willing to settle otherwise. The ethical standards that the mediator needs to have has also been highlighted, which is very instructive indeed for all of us. The need to have domain knowledge is extremely important. It's important so that parties, when they're expressing their case, should know that mediator also knows the law. It's not that the mediator can be taken for, if I can use a loose expression, taken for a ride by the parties by saying whatever the parties want to say. So domain knowledge is important to understand what is the dispute, what lies at the core of the dispute, and how best we can help them resolve without expressing any views on the merits of the matter. We are confident that in times to come, the mediation would emerge as the first recourse to resolution where parties would not want to go to the courts. The court or adversarial litigation would really be the last recourse to parties. We are really waiting and looking forward to that day. I'm sure it's not far off. We can see it in future. How long will it take? We don't know. But I think we as mediators must continue to strive towards that and ensure that parties don't lose faith in this process. They are attracted to this process and resolve their disputes through negotiation, through talks with a trained mediator. So we are grateful to you for your insight and guidance today, and we hope to continue to have such discussions even in future, where we can discuss, we can evolve newer methods, we can be guided, and have a fruitful outcome of your experience and your guidance towards all of us. Thank you very much.
Thank you, Rajiv. It's now time to conclude today's session with a promise from our panelists and from all participants that we'll continue to have many more such programs. In all humility, I thank Justice Kaul and Justice Sikri for always being with us as our guiding force. I thank Mr. R. Venkataramani for his motivating thoughts on the new age leadership required in mediation. I express my gratitude to Honorable the Chief Justice of our Delhi High Court for sparing his valuable time for releasing our calendar and making this moment a memorable one. I thank Justice Manmohan, our chairman, along with Justice Sachdeva, Justice Yashwant Verma, Justice Naveen Chawla, and Justice Sudhir Jain for extending their continuous support to us. I express my heartfelt thanks to all the honorable judges for being with us as always. I thank the moderators and Sadhna and Sudhanshu who have worked on and off the dais along with JP in conceptualizing today's panel discussion and articulating questions to get valuable and incredible knowledge and information from our panelists. I thank all the principal and session judges, all family court judges, coordinators of various mediation centers, Mr. Mohit Mathur, Jatan Singh, and Sandeep Sharma, President, Vice Presidents, and Secretary of our Bar Association, all the executive members for being there with us always. I thank the Registrar General, Mr. Dudeja, and his team, Mr. Rawat, Mr. Neeraj, Ms. Sunita, Ms. Veena Kumar, and the entire PWD IT teams, Mr. Sareen and his team, for their enormous efforts in organizing today's event. I also thank the dedicated staff of Samadhan for their immense efforts, without whom this program would not have been possible. I thank all of you being here today in such a large number. Thank you, everyone. May I just request now the guests, I kindly wait for our panelists and our honorable judges. Let them leave first, then we will request rest of the people to leave. Please, sir. Thank you once again. May I give them a round of applause, I think. Please join for high tea. For my mediators, friends, please go on your right side. There is a high tea arranged for you.